Good morning, everybody. We're going to call to order this October the 16th, 2014, the Alarm Systems Contractors Board Notice of Board Meeting and Rulemaking Hearing. We welcome everybody that's in attendance today. And Ms. Vess, I'll turn it over to you for our roll call.
All right. Scott Cockroft.
Here.
Keith Harvey. Vivian Hickson.
Here.
Karen Jones.
Here.
Mackenzie Roberts. Let the record show that Keith Harvey and Mackenzie Roberts are not present, but you do have a quorum, Madam Chair.
Mr. Kilgore.
Thank you. Now that the rulemaking hearing is called to order, my name is Josh Kilgore, and I serve as staff attorney in the Department of Commerce and Insurance, Division of Regulatory Boards, and serve as attorney for the Tennessee Alarm Systems Contractors Board. Would the agency representatives who are present please introduce themselves for the record?
Cody Vest, Executive Director.
Beth Bell, Administrative Assistant.
It is Thursday, October 16th, 2014. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 45204 in Conference Room 1B of Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on rules the Tennessee Alarm Systems Contractors Board is proposing to update certain existing rules relating to topics such as the duties of a registered employee and qualifying agent, changes in renewal procedures of registered employees, and providing notice of criminal charges and convictions, and introducing a code of conduct relating to door-to-door solicitation to limit deceptive practices. The Tennessee Alarm Systems Contractors Board is proposing these rule amendments and new rules because the board has identified the need to further clarify certain provisions of existing law in order to better protect the public health, safety, and welfare. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notices given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table at the front of the room, and only those who have signed will be permitted to speak. Notice of rulemaking hearing included the entire text of the proposed rules and was filed with the Secretary of State and published in its Administrative Register website on June 24th, 2014. Ms. Vest, what additional notice was given to the affected individuals or groups?
Information regarding the rulemaking hearing, as well as a link to the full notice of rulemaking hearing, was sent by way of electronic mail through the use of the Notify system on our database August the 18th, 2014. The entire text of the proposed rules was posted to the Alarm System Contractors Board website on September the 11th, 2014. And then we also put it on the September Administrative Register.
Thank you. As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. And I will read the substance of the proposed rules into the record. Starting with Rule 0090-01. -.05 employee registration requirements, which is amended by deleting the text of paragraphs 7 and 9 in their entirety and substituting instead the following language, so that as amended the new paragraph shall read 7. If an active registered employee leaves the employment of a contractor, the employee's registration will be placed in an invalid status until such time as the alarm employee registration is transferred to a certified alarm contractor or until the registration expires. Number 9, renewal. Part A, a registration shall expire on the last day of the 24th month following its issuance or renewal and shall become invalid on such date unless renewed. A new application for employee registration, including new application fee as established by Rule 0090-01-.09 fees, shall be required to be submitted if such renewal application is not timely submitted to board by the date of the employee registrant's expiration date of the last day of the 24th month following its issuance or renewal thereof. Part B, an alarm systems contractor shall apply to the board for the renewal of the registration of each registrant employed by the contractor by submitting the required renewal application, including the requisite renewal fee and 2 frontal color photographs for each renewal registration as established by Rule 0090-001 or -01-.09 fees. Part C, upon initial implementation of this part, all registered employee registration expiration dates will be set to coincide with alarm systems contractor with whom they are affiliated as of the effective day of these rules. All registered employee renewals thereafter will be the last day of the 24th month following issuance or renewal thereof per Rule 0090-001-.059A. D, an alarm employee registrant who has not met the requirements for renewal of registration by the expiration date of the registration shall cease acting as an alarm employee for any firm until all requirements for registration renewal, including payment of any fees for late renewal, have been met. E, no alarm employee registrant shall receive a renewal when such registration has been in default for failure to comply with TCA 6232-301 et sec for a period of 3 months. In such event, the alarm employee, in order to qualify under the law, shall make new application and meet all current requirements to obtain a new registration. Rule 0090-01 -.08. Oh, 0.06, I'm sorry. Qualifying agent requirements is amended by deleting paragraph 9(1) in its entirety and substituting instead the following so that as amended it shall read.
That's
9I, I'm sorry. My copy isn't that good. A designated qualifying agent must perform the following. A designated qualifying agent shall notify the board within 30 days after a registrant, applicant, or qualifying agent has been convicted or arrested that is known or should have been known to the designated qualifying agent. Designated qualifying agent shall provide this notification for persons who are registered or required to be registered under the alarm systems contractor that employs the designated qualifying agent. The designated qualifying agent shall provide notification if registrant, applicant, or qualifying agent was convicted in any city, county, state, federal, or military court of any crimes except minor traffic violations. For purposes of these rules, conviction means the entry of a guilty plea, no contest plea, or a verdict or decision rendered by a judge or jury. Rule 0090-01-.07, Alarm Systems Contractors Requirement, is amended by deleting, quote, listed in TCA 6232-303, paragraph 8 from paragraph 10 and substituting instead the phrase, except minor traffic violations, so that as amended the paragraph shall read, the contractor or designated qualifying agent must notify the board within 30 days of any known conviction or any conviction of which the contractor or designated qualifying agent should have known of. Any designated qualifying agent or registered employee under their supervision by any state, federal, or military court of any crime except minor traffic violations. For purposes of these rules, conviction means and includes the entry of a plea of guilty, pleas of no contest, or a verdict rendered in open court by a judge or jury. Rule 0090-01-.09 fees is amended by adding paragraph 6, so that as amended, the new paragraph shall read, the examination fee shall be the fee charged by the entity administering the examination, subject to board's approval. And I'm going to ask the board now to consider an amendment to this rule 0090-01-.10 on renewal of certification and license. What happened here was the enabling clause is broader than what the board originally intended. And you can see there it says is amended by deleting the section in its entirety and substituting the following. But I think that it's evident by the original filing where it skips to section 2, 3, 4, and then skips from there to sections 9 and 10, that sections 1, 5, 6, 7, and 8 were inadvertently left off of that. And per the board's original intent to only amend the sections as included 2, 3, 4, 9, and 10, I would now, and I've passed a handout to the board, now ask that the board read that and accept the amendments, which include the language as the rules are now written on those sections that are underlined in red, which would be sections 1, 5, 6, 7, and 8. And on the board's copy, sections 2, 3, 4, 9, and 10 are actually the new amendments to the rule that were originally intended by the board. And the sections in red being the sections that the board wanted to be left as they stand now.
I've got some questions on a few things. Do we need to go through all of it with you reading it first before, or, okay.
Okay, well, I think on this one matter, on this particular rule, I think the board might want to take it up separately and make a motion to adopt as amended, and then take the other rules. If the board wants to do it separately, they can do it separately. If they want to make a motion and vote on each rule separately, or we could just take up all the rules at the end and do a broad motion to go ahead and adopt all of them. It's up to you.
I think first we do need to have a separate amendment to reinstate these subsection 1, 5, 6, 7, and 8 that were deleted from Rule 0090-1-.10. Do a motion separate on that, and then it would be, I guess, the board members' choice if they want to vote on each rule separately or in mass at the end. But I do one of y'all want to make a motion to reinstate these that were inadvertently deleted due to the language?
Sure, I'll make that motion. Do I need to say that all together?
Yes, you need to make the motion.
Okay, so I would make a motion that we add back, reinstate the items omitted from 0090-01-.10.
Second.
Okay, we have a motion by Mr. Cockcroft and a second by Ms. Jones to adopt this amendment by reinstating these deleted subsections. All in favor, voice by saying aye. 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 All opposed? The motion carries.
Thank you. And as adopted, I'll go ahead and read how that rule is now going to be. Number 1, as used in these rules, the requirements contained in TCA 6232-317 are applicable. 2, each certificate and license shall expire on the last day of the 24th month following its issuance or renewal and shall become invalid on such date unless renewed. 3, company certification renewal notices shall be mailed by the board 90 days prior to the expiration date of the certification. Qualifying agent license renewal notices shall be mailed by the board to the last known business address 90 days prior to the expiration date of the license. Such renewals must be received in the office of the board 30 days prior to the expiration of such certification or license. 4, the board shall notify every company certificate holder and qualifying agent licensee by mail to the last known business address of the date of expiration of such certificate or license and the fee required for its renewal for 2 years. 5, applications for renewal of the company certification shall list all persons required to be licensed or registered in accordance with TCA 6232-312A. 6, no qualifying agent license shall be renewed unless the board has received satisfactory evidence of the completion of continuing education prior to renewal in compliance with minimum satisfactory standards set forth in Rule 0090-05-.01. 7, a qualifying agent who has not met the requirements for renewal of qualifying agent license by expiration date of the license shall cease acting as qualifying agent for any firm until qualifying agent has established to the satisfaction of the board that all qualifications for renewal, including the payment of any fees for late renewal, have been met. 8, the fee to be paid for renewal of a company certificate or qualifying agent license after the expiration date shall be increased 10% for each month or fraction of a month that payment for renewal is delayed, provided that the maximum fee for a delayed renewal shall not exceed twice the normal fee. 9, no company certificate holder, qualifying agent licensee, or alarm employee registrant shall receive a renewal when such company, agent, or registrant has been in default and compliant with TCA 6232-301 et sec. For a period of 3 months. In such an event, the alarm systems contractor, qualifying agent, or registrant, in order to qualify under the law, shall make new application and meet all current requirements to obtain a new certificate, license, or registration. 10, the alarm contractor, in order to renew its certification, shall submit to the board on board-approved form a notarized statement of the contractor's designated qualifying agent, chief executive officer, or any other authorized contractor representative, which identifies the number of employees required to be registered with the board, as well as a list containing the name and registration number of each employee who is registered or required to be registered with the board. Moving on to the new rules now, which will be chapter 0090-06. Which is the standards of conduct. First is the applicability, which states the provisions of this chapter shall apply to any person or firm licensed and or registered by the Alarm Systems Contractors Board to conduct the sale, service, maintenance, installation, and or monitoring of alarm systems in this state. For purposes of this chapter, unless the context otherwise requires, the word licensee includes any person, partnership, corporation, or any other entity certified as alarm contractor or licensed as a qualifying agent. And then Rule 0090-06-.02, door-to-door solicitation. 1, a licensee or employee registrant who sells, offers to sell, or attempts to sell alarm systems as defined in TCA 6232-303-1 to a homeowner or resident of a home or apartment through direct physical contact, including door-to-door solicitation, shall A, carry an identification card or a copy of a currently pending application for license or registration issued by the board and present said identification or proof of registration for inspection to the homeowner or resident. B, truthfully and clearly identify themselves by name, their full registered company name, and the purpose of their solicitation to the potential customer at the initiation of a sales presentation without request from the consumer. No licensee or registrant shall generically identify themselves as being from, quote, the alarm company or, quote, the security company, C, provide to the homeowner or resident at no charge a document or business card listing the person's name, employer's name, address, phone number, license number, and the board's phone number with instructions on how to contact or file a complaint with the department. C, not approach or solicit a home or residence at any time where a placard, sign, or any other posting of whatever nature is displayed indicating that the homeowner or residential occupant does not wish to be solicited. E, comply with any applicable door-to-door solicitation ordinance consistent with state and federal law. Section .03, Standards of Conduct and Ethics. 1. An alarm systems contractor, licensee, or employee registrant shall not engage in any deceptive, misleading, unlawful, or unethical business practices with customers or consumers. Such practices shall constitute improper, fraudulent, or dishonest dealing pursuant to TCA 6232-319D. Part 2. A licensee or employee registrant, when engaging in the sale, installation, service, or maintenance of alarm systems, shall not falsely state or imply the following to a potential or existing customer. A, that a competitor company is going out of business or is in financial difficulty, or that such competitor company no longer exists. B, that a competitor company is changing or has changed its company name. C, that the licensee or registrant is a representative agent of, is acting on behalf of, or is otherwise acting with the consent or approval of a competitor company. D, that the licensee or registrant's company is a, quote, sister company of a competitor or is acquiring, merging with, or has taken over or purchased the competitor's company's accounts. E, that the licensee or registrant is performing routine maintenance on competitor company's equipment which is in the possession of a customer. F, that any material change proposed during a sales solicitation is an update or upgrade of an existing alarm system when such transaction requires an agreement with a person, company, or entity different than the customer's existing alarm system or alarm monitoring service agreement. G, that the licensee or registrant's company is affiliated with, has the endorsement of, or is in any manner acting at the direction of any governmental or law enforcement agency. And H, quoting statistics or providing other information that is known to be false or misleading, in which the licensee or registrant has not made a reasonable effort to objectively quantify or substantiate. Section .04, Contracting with Customers. 1. When contracting with existing or potential customers, alarm contractors shall require employee registrants to use written materials which clearly and conspicuously set forth both the alarm contractor and the customer's rights and obligations. 2. Alarm contractors and their employee registrants shall clearly and conspicuously disclose all material terms and conditions of the offer before obtaining a customer's consent. 3. Alarm contractors shall train their employee registrants with respect to the terms and conditions of the contract so that a customer's questions can be adequately answered at or prior to signing the contract. 4. Alarm contractors shall require their employee registrants to provide a copy of the contract to customer immediately upon execution. 5. Refund policies, including termination fees, shall be clearly and conspicuously disclosed to existing or potential customers prior to the sale of any alarm product or service. 6. Alarm contractors shall honor all refunds for customers in accordance with their stated refund policies. And 7. Upon request, alarm contractors shall provide customers a written termination fee calculation and statement of the information upon which they base the calculation.
Did you read the changes to this one? I thought you read this, but this doesn't match what's in this. But I understand we were adding the red, but the black doesn't match.
No, we're adding the black. Aren't we adding the black?
Black is what was changed through the rulemaking hearing, but the red is what was accidentally deleted from the rulemaking document.
But the black does not match what's in this document. Because the black says, it says we're going to start mailing renewal notices to employees as well, employee registrations. Is that not true?
Just a second.
Let me get there.
On page 3,
It's subsection. It's subsection 3, is that correct?
well, yes, subsection, I was just at page 3 of this document, but it's subsection 3, where it says company certification, qualifying agent, and
Oh, they left that
alarm
off the
employee.
red line copy.
Was that the intent, to start notifying employee registration as well? I thought that,
Yes, the employer will be notified at the company. The company now will be receiving the renewal notice on each one of their employees
I
at the
thought that was
company.
a great improvement. I just want to make sure that still made it in there.
Yes, sir.
Okay, yeah, I apologize for that. It does appear that the red line copy that I handed out has a discrepancy there. For the record, on subsection 3 of rule, the part that was noticed on rule 0090-01-.10, part 3 should state company certification, qualifying agent license, and alarm employee registration renewal notices shall be mailed to the last known business address 90 days prior to the expiration date of the license, certification, or registration. Such renewals must be received in the office of the board 30 days prior to the expiration of such certification, license, or registration. Is that the part that you were talking about? Okay. Yeah, that was actually on the original notice, but somehow it didn't get transcribed onto the red line.
Well, I think there's a little variation in the next, in 4 also, if it makes a difference. It appears that an alarm employee registrant by mail, the alarm employee has been omitted on the red line as well. I think it's easy for us to correct. We can go back and make another motion to accept the red line copy as presented with the exceptions of paragraph 3 and 4. And that would go back to the original rulemaking notice.
Yes, ma'am.
I think that's the only two.
I believe sections 3 and 4 on your red line copy are the only instances where reference to an employee registrant were left off.
I would make a motion that we with the language that was deleted as it was just read. I don't know how to phrase that. I'm sure that's very.
Back to the, I think you want to make a motion to revert back to subsections 3 and 4 of the original rulemaking hearing to be adopted versus the one that were presented in the amended copy. Would that satisfy it, Josh?
Yes, that sounds correct.
Okay.
Oh, it's so moved. Or do you want me to read that whole thing?
Just make the motion that we're going to amend it to revert back to the original subsection 3 and 4 in the rules making hearing notification. And then we'll get Karen or me to second it.
I move that we revert back to the subsections 3 and 4 that were published in the original rulemaking hearing notice that includes alarm employee registration renewal notices to be mailed.
For rule.
For rule 0090-01-.10.
Okay. We have a motion and a second to make an amendment to this Rule 0090-01-.10. All in favor, voice by saying aye.
Aye.
All opposed? I think we have it the way we want it.
Thank you.
Thank you.
I would like to ask the board if they would make a motion to enter the red line document as Exhibit 1 to this rulemaking hearing for the AG's office. And also, I think you could do it maybe in one motion, make Exhibit 2 the notice of rulemaking hearing as Exhibit 2.
Before we move any further, did that address the concerns that you had noted in both documents? I know you said there were, when we were discussing earlier about whether to vote on these in mass, or were there questions in the
I
other
do have
different-
some other questions, and even in that particular
Do you
one.
want us to address that, Scott, Josh, before we move to do the exhibits in the rulemaking as Exhibits 1 and 2?
That should be fine.
Okay, let's go ahead and let Mr. Cockcroft address whatever issues he has with the particular rules changes, and then we'll vote everything there at the end.
In that particular, in the 90-01-.10, I know this is the way it's been stated before. It says must be received in the office 30 days prior to expiration, but we do still accept them after the 30 days, do we not?
Yes.
Could
To
we
answer
change
your
that
question.
wording to shall, or should, not shall, but should? Because must sounds like you would have the ability to deny it, to say it's after the 30 days. I know you don't do that, and that hasn't been the case. But that would change the wording to match more closely what we're actually doing.
All right, which one is that, Mr. Crawford?
Page 3, subsection 3, on the original document, and I think we are reverting back to that particular one with the last motion.
I understand it's the intent. I mean, the intent, it should get there 30 days prior. That's not always possible. And
Very seldom do we ever get them 30 days in advance anyway. I'll just let you know, it just doesn't happen that way.
right,
So what you're talking about is such renewal should be received in the office of the board 30 days prior to expiration of such certification. The one before that says, company certification, qualifying agent license, and alarm employee registration renewal notices shall all be mailed to the last known business address. That means that's what we have to do. We have to mail it to whatever the last known address I have on the system prior to the expiration date of the license, certification, or registration. That tells me that we're the ones that have to mail that to you.
Right, and-
That's in the law.
Yeah,
and I think that
that's
should
wrong.
be, I mean,
Okay,
that
that's fine.
is correct as it's
All
written,
right.
shall be 90 days.
Such renewals must be received in the office of the board 30 days prior to the expiration of such certification, license, or registration. So you're talking about changing the word must.
Correct.
Is that correct? Is that something that can be done? I know if
If the
it
board
doesn't,
makes a motion and votes to adopt the amendment proposed.
all right, so what is the suggestion from the board to replace the word must?
I would make a motion that we,
What are your changes? She's asking,
Or what?
what do you want to change the word to?
to should, and not shall or must, but should.
Change the content of the, oh, that won't change the content of the rule, will it? Just a minute, I was talking with the attorney, just say, I gotta make sure, or we do, make sure it's not gonna change the intent of the rule. It would, so we wanna replace the word must with should. I mean, that's up to,
We can, I'm not sure that it's gonna make a difference in practice.
I don't either.
You still got a 90-day,
You're not on.
it says speak, oh, well, if you don't have it in after the 90 days, you have to retest, reapply, everything. I don't,
Let's let Mr. Cockcroft go ahead and make his motion, and if it dies for lack of second, we'll move forward. So you want to go ahead and propose your motion?
But I'm not sure if you're following what I was saying from the standpoint of must versus should. If you wanted to leave it must, it could be before expiration, but the fact that it must be 30 days before renewal is my concern.
Well, it says 30 days prior to expiration.
So if I sent it in 5 days before expiration, and it said I must, and then what happens? I mean, if I must do something, I didn't do that, so I shouldn't, according to this, I shouldn't get my license renewed, but y'all do that. That's my concern. I think that changing that word would make it more aligned with the practice that's actually being done. If someone sends it in within that 30 days, you don't say, oh no, you can't renew it. You go ahead and renew it. So
Right.
this wording says that must, so that would suggest that you wouldn't renew it.
Well, then you move on to 9, and it further
You have a
explains
leeway.
that you've got 90-day leeway, so.
Now, that 90 days is not a leeway. That, you're supposed to have your renewal in here before your expiration date.
But 9
It-
makes a provision that you
Right,
can,
but no,
though.
but what it's supposed to be, the intent is, then you're expired, but you have got 90 days to get back into compliance. You don't continue to work and whatever. You've got those 90 days to get back into compliance before you have to reapply and do everything all over again. I mean, personally, I don't have any trouble changing the word. It's just a word change.
Right.
I don't
I'm
think
not
it
trying to make
changes the content.
I'm not trying to make a
intent.
mountain out of a molehill, but I thought that would make it closer to what we're actually doing. But so do I need to make that in the form of a motion in Rule 0090-01.10 subsection 3, where it says such renewals must be received, to change the word must to should.
Okay, we have a motion by Mr. Cockcroft to change the language in Rule 0090-01-.10, change the word such renewals from must to should. Do we have a second? We have no second, so the motion dies for lack of a second.
Sorry.
It's okay.
Where we're talking about providing the homeowner,
Tell us which page
Okay.
and which section
Sorry.
it's easier to get.
it's Rule 0090, it's page 4. It's dash 06.02. It's C, where we're asking to provide the homeowner a document, business card. Is the board really prepared to receive the level of the responses that they may get? Some people are going to respond to this just the fact that they were door-to-door solicited, and that's not a violation, but the fact that we're passing out a card, and it also says instructions how to contact, that seems vague to me. I mean, what are the specifics of what should the instructions be? Should there be the instructions merely to file a complaint, call this number? But I think that's going to generate a lot of phone calls to the board, because there are going to be people calling that just didn't like being solicited door to door. And is that really something that are you going to be able to handle that?
Yes, sir, we already get those kind of telephone calls. I think the way I read it, the intent was to make sure that whoever is knocking on your door identifies themselves properly by using a business card or whatever form else it says here, that it, name of the company, who they work for, their address, telephone number. I believe that's what this intent was.
Which I don't have a problem with that at all. I guess it's the fact that it's adding the board's phone number and instructions on how to file a complaint.
complaint.
Because that's going to require a lot of people to do printing or reprint business cards, and that is an economic impact thing. The other thing is, it's not clear to me. My interpretation of this entire section is virtually any alarm sales. It says direct physical contact. Does that to mean that someone calls an alarm company once you're out there? Because it says including door-to-door sales. It doesn't say just door-to-door sales. So does that mean that all of this is aimed at virtually every alarm sale is made face-to-face in someone's home or business? So is that to say every single time, you know, that a card's going to have to be presented with the board's phone number and instructions on how to file a complaint every time an alarm sale is made, whether it's door-to-door or not? What was the intent of this?
Well, the intent was where we had a lot of questionable door-to-door salespeople going, and where people already had alarm systems installed with monitoring. Some were saying they were upgrading the system, and then actually it was a competing different
putting
branch of the same company, and then the people were getting stuck with two monitoring and an upgrade fee and all that, and it was more to stop the door-to-door sales and give guidance for what these people can and cannot do, especially to those who already have alarm systems installed. We had a lot of out-of-town people come in and canvass in neighborhoods. It wasn't.
And I've seen some of those problems as well. The part of the problem with some of that is the people that are doing the unscrupulous things aren't going to give out this card anyway. Of course, that's when I guess then action can be taken. But
I think what we're looking at on that door-to-door solicitation was C. Perhaps we didn't quite consider that. You're probably right when it says everybody will have to make a business card, new business cards, and have on the instructions on how to file a complaint. Of course, we have all that information on our website and all the kind of documentation that we have anyway. So if that's to be removed, the board would need to make a motion just to remove on how to contact
After license number.
Yeah, after
So-
license number, put a period.
And license number.
Phone number and certain, to take out the part about file a complaint. I don't believe that changed the whole the intent of that sentence, paragraph, excuse
No,
me.
because you're requiring the solicitor to give the homeowner some type of document to refer back to, identifying them, their company, and how to contact them and so forth.
Right, that was the intent, yes, ma'am.
Exactly, yes. Okay. You want to make a motion to delete the last part of that phrase and end it with "and license number, period," deleting all language from that point forward.
so it would be
Period, and delete everything from "and the board's phone number with instructions on how to contact or file a complaint with the department" would be in your motion deleted.
I guess that would then clear up the standpoint, even if this does apply to every sale, because I think everyone should give a hand of business on any sale.
As a consumer, I would ask for, I
Right.
mean, you're gonna have to have some form of identification to sell me an alarm system, and I'm sure that you should have a business card if you're working for a company.
Well, I would make a motion that on Rule 0090-06-.02, Section C, to word, or after phone number, put "and license number, period," and delete the rest of the, "and the board's phone number with instructions on how to contact or file a complaint with the department."
We have a motion by Mr. Cockcroft to amend Rule 0090-06-.02, door-to-door solicitation, Section 1, subsection C, by inserting the word "and" after phone number, period after license number, and deleting the language "and the board's phone number with the instruction on how to contact or file a complaint with the department." Do we have a second?
If it pleases the board and it will help clear up things, I'll second.
Okay, we have a motion and a second by Ms. Jones. All in favor, voice by saying aye. Aye. All opposed? The motion carries. Next one.
All right, the other concerns are all it's the last, I believe it's the last rule, that's 0090-06-.04. We've used, in paragraphs 1 and 2, we have the words clearly and conspicuously. And I know that this may, once again, sound like I'm making something out of nothing, but that seems vague to me. I mean, what are we saying, that it has to be on the front of the agreement, that it has to be in a certain size, or what defines clearly and conspicuously?
I don't think the board's in a position to actually get down to a point where we say you should have it in your header on page number 1 of every contract. I think what they're trying to do is just make sure that the consumer is aware and it's written in a form that they can understand.
And then on the same term, which I guess that does get back to,
If I could.
yes.
If I could, sir. I apologize. I'll introduce myself again. I think I was here last meeting. Tony Glandorf. I'm the Chief Counsel for Regulatory Boards. And I think maybe I could address your question as to clearly and conspicuously. Clearly and conspicuously are generally words that are used in many industries when it talks about notice or disclosures to consumers out there. Generally, some of the boards do actually make definitions as to what that will be because they have a specific reason why they want it. You know, there's some things like signage may be, your sign has to be clearly and conspicuous, and clearly is maybe 8 inches tall or whatever, but here you're talking about a form, and generally without that definition, they would go back and look at what are the industry standards in that. What is the industry standard on a clear and conspicuous form, so that the commission or the board here in this instance could go back and say, well, my interpretation of clearly and conspicuously is that all of the wording on the form, all the letters have to be of the same height. This is generally accepted practice within the industry. This is what 90% of everyone does. What we have in front of us is a form that does not meet that requirement. So based on that, we would say that it's not it's not clear or conspicuous. Does that make sense for you? That's one way that boards interpret that. So yes, it can come off slightly as vague or maybe actually ambiguous in a way, but some boards have taken the definitional approach of we're going to use the industry standard, and you all also independently can say, even without the industry standard, collaboratively as the board, this does not look clear or conspicuous to us. So you all could make that interpretation when presented with one at a hearing in the future. So I hope that clarifies. Thank you.
Thank you.
Still on that point, where we're saying that our employees should be trained I get the gist of this. I mean, but it concerns me that we're saying that an employee has to explain a legal document to a customer. I mean, some attorneys will counsel for salespeople not to. You know, if the customer has a problem with it or a question about it, they should seek counsel. But the fact that we want our employees, or that we're expecting an alarm, an alarm company employee to start explaining terms and conditions of a contract concerns me.
I guess my question is, they couldn't explain it.
Are they selling it?
I wouldn't, personally, I wouldn't sign it when you're selling it to me right then, and then you're telling me to maybe stop and contact my own attorney, when I would expect the person who's selling me this system to be able to explain the terms of the contract.
Yeah, I mean, I read it as they don't have to go into such detail and give them, the legal interpretation, but they should be able to give them an idea of how long the contract's going to run and, how much it's going to cost them and the general aspects like that. I mean, it seems like a lot of
I don't mean to interrupt, but if the door-to-door salesperson was, they could give the consumer a copy of that, and they could have time to consult with an attorney or a legal advisor to make sure that it was okay for them to enter into it. I think it's a protection for the consumer from the industry to say, this is what we're going to provide for you and how much, versus it being a very technical legal document. I think it's just so that these companies have to disclose what services they're going to provide, how and how much. Is that
Yeah, I mean, I think,
the gist of it?
Intent.
My concern though here,
Intent, yes.
again, is also, this goes back and includes virtually every alarm sale. It's not just door to door, my reading, my interpretation of it, and that may be wrong. That would make me feel a lot better about all of it if we cleared up that this was primarily aimed at door to door sales. There is already a federal, I think it's a federal law, that's the 3-day right of rescission that they do have. Even if they sign it, they've got 3 days to cancel the agreement.
Well,
This is not meant specifically
Right.
for door-to-door. It
Across the board.
covers all, across the board, contracts for alarm installation services and so forth. But I think a lot of this problem did start with the door-to-door solicitation. So instead of just singling out that one particular part of the industry, this is covering all alarm sales so that all consumers are protected by these statutes against an oral contract. They're given something in writing. And you're right, there's a 3-day review process that would trump this, but, this is a protection for the consumer against phone calls, door to door, however the contact is made.
Well, wouldn't you want an employee to be able to tell somebody over
I
the
would.
telephone how long the contract's gonna be for, or how much
And the
it's
terms
gonna cost?
And the thing
terms
is,
Terms and conditions,
exactly.
you
And
want that person to do
you're going to
that.
give them a written copy of it so that
Well, not over the
consumer-
telephone you wouldn't,
Well,
but you
not
still.
over the telephone,
If you're
but
gonna try to sell me a system, I'm gonna ask these questions.
It's true.
And I definitely don't condone a lot of the tactics that are done on the door-to-door sales that I know what we're trying to combat. My concern is that we turn things so that we degrade what a legitimate agreement is, and then a customer can go back and say, well, it was explained a certain way. The alarm industry in general is definitely very much based on the fact that an alarm company is selling a service and they're not selling insurance, and that's the biggest part. I guess that's really where the crux of it gets, where my concern is. That's a lot of times where customers, a lot of their questions are about the limitation of liability and whether they're an insurance company. And I don't think a salesman should be rephrasing that and saying, oh, well, we're just not an insurance company, or making it much smaller than it is. I mean, it is a legal document, and it's
If it is a telephone sales, like the example used a second ago, there's got to be one-on-one contact at some point. If the person says, yes, I would like to have a system installed, that when that installation is done, or before the installation's actually started, they would be given this contract to review it. Because, the alarm company is going to have a contract regardless. They're not going to come out
Right.
just on word of mouth and install a system that's got requirement for monitoring for so long or so much monthly payment on the system itself. They're going to have some type of contract to ensure they get their payment.
I missed what you were aiming towards there. Did somebody say something about?
Yeah, Cody did. I was using, and she said, well, you wouldn't be able, if it was a phone sale, you wouldn't be able to hand the person the document. But I
Right.
said at some point in the process, there would have to be face-to-face contact, which that written document could be presented, even if the call initiated through a telephone call. As subsection 4 kind of covers that. It says that alarm contractors shall require their employee registrants to provide a copy of the contract to the consumer immediately upon execution. So that covers, when there is a face-to-face.
Then the last and final is about termination fees. Are we requiring that all alarm companies now have a termination fee? Is that what this is aimed at, or is it merely to disclose?
I think it's kind of like a cell phone company. If you early terminate your cell phone service, some companies do have an early termination fee, and I think it's a protection to let the consumer know if you have a 3-year, for example, contract and you terminate it after 21 months, you could or could not be liable for the next 15 months of that contract. I think it's to let people know if they terminate early, this is what the liability is. It's
I
just
mean,
a
I don't think we're
disclosure.
requiring them to have a termination fee. I think we're just
We're just making them
saying
say,
if they
you've
do,
got one, these are
right.
the conditions.
Because typically, right now, a lot of it is if they don't fulfill the contract, it's a breach of contract, and it's the balance of the contract. A termination fee might be less than the balance. It might be more, I guess. I guess if we said they have to have a termination fee, it could be something that was more than the value of the contract.
I don't think we're in a position to make a company have a termination fee. I think we're just saying, if you have one, you have to explain it to the customer up front.
right. I mean, because a
I mean,
lot of
that's how-
customer
that's how I
complaints are
read it.
about they have voiced their concern and wishes to cancel a contract, and the company says, well, you didn't submit it in the proper form because it's supposed to be in writing within 90 days of the expiration date, and customers don't understand that. And I don't think that the board is trying to interfere with the company's rights to contract, and the customers do still have obligations under that. I think that we're just saying
If
that the
you
company
have
should be
one.
upfront with their fees, and it goes in line with being, clearly and conspicuously stated, and not try to hide it in some very small fine print, at the bottom somewhere. I think that's the whole intent of all these that we've gone over.
The last 7, it seems to me that because it's addressed, the termination fee is addressed in 2 paragraphs or 2 subsections, because the last one says, upon request, the shall provide a written termination fee calculation.
Well, I mean, that's assuming that they have a termination fee. I mean, if there isn't a termination fee in the contract or the company's policies, then I don't see how they could ever be required to provide one.
That's my concern on both of those issues, that we're not dictating something that if they don't currently do that they have to at this point.
Do you have a motion that you wanted to make on either one of those, 5 or 7, about the language?
So on 5 or 7, if the interpretation is that we are not dictating those things, I don't have a problem with that. The biggest problem I have is 3. That's that the employee is supposed to, because this could be taken to extreme. I understand they should be able to say this is a 36-month agreement. It's X amount of dollars per month. But to say that they have to explain the entire contract, they're not lawyers, and they shouldn't be expected to explain a legal document.
I agree with you, but there's industries, cable television, all industries that have customer service reps versus employee registered people that do this every day that are not attorneys. It just says, these are the terms and conditions, you accept them or you don't get the service. And I don't think I don't agree that it's getting into a legal field, because once again, we go back to, you're not being forced to take this service. This is our terms, but you're not mandated that you have to accept them. If you don't, you can go to another company. But if you do have terms and conditions, we're saying that the salesperson should be knowledgeable of these so that they should be able to answer basic questions that the customer may have about it.
I understand your concern. I just think that when and if that case comes before the board, that it'll be there's a certain amount of discretion that the board has. I mean, when it gets into the more technical aspects of a contract, I don't think that the board would, reasonably expect that salesperson to have gone into every little detail. But I think that the general purpose of the rule is that it's
to protect the consumer.
they should be able to explain it like you were saying.
I would think most companies would have a legal advisor review any type of contracts before they would be presenting it to the consumer anyway, to protect themselves.
I guess I feel like I'm fighting a losing battle here, but I would make a motion that we remove 3 from 90-06-.04. I already have 2 that says the employee shall clearly and conspicuously disclose material terms. I don't feel like we need 3 that says that the employee registered 3 says alarm contractor shall train their employees with respect to terms and conditions of the contract so that the customer's questions can be adequately answered at a.
Okay, Mr. Cockcroft has made the motion to delete subsection 3 from Rule 0090-06-.04 in its entirety. Do we have a second? Motion dies for lack of a second. The subsection 3 will remain.
Which I realized that didn't make much sense. I could remove the training after I read it, I realized that doesn't make sense, but
Correct.
sorry.
Okay.
But
That's all right.
I
Anything else?
no.
Okay. Now,
Scott, we know that you were not here whenever the board had, we went over these and did this rule, and wrote these rules, but I want you to know, we really appreciate your input on this morning on discussing of these, because you saw some things that we did not apparently see.
and a lot of the rules, too, are based on some of the issues and complaints that we've had in the past, that we found we had weaknesses in our rules that we needed to address based on some of the investigations and complaints that Mr. Kilgore and previous Mr. Simpson
I just think
had
we're
presented.
overstepping into contract area where it's stuff that's civil, that's not, that shouldn't be before this board. But there have been other issues with contract-related stuff that's in the past. It's been said that's a civil matter, and I think we're opening up a whole new gamut of stuff with this. I understand. I wholeheartedly agree with the stuff about door-to-door sales. I just think that we've got a few other things added in here that could be much bigger than they were intended.
They have to continue to review those and say this is a civil matter and the board not address the issue, because it still has that potential that it could go for, as civil. Okay. Anything else? All minds clear on that? All right, Mr. Kilgore, you ready to proceed with your exhibits
Well,
amendments?
actually, at this time, I think we have some members in the audience that may have some comments. If
Do we have any members of the public that would like to come forward and did you sign in, sir?
It's up on the podium.
I'm sorry, it's, okay.
It's for the rulemaking hearing, sign in. There you go.
Howard, there's not a microphone there, so you're gonna have to really speak up.
Or sit at the table
Or
over
sit
there.
over there at the table of that mic if you would. Thank you.
Good morning. Howard Constam. I'm with Video Guard Integrated Technologies. I really hadn't planned on speaking. I really wanted to address the last section that you were just discussing. What I see, this is just good business practice. I don't have any problem with it. I see where you're coming from. But we're not dictating what's got to be in the contract. We're saying this is a good business practice. It's going to be good for the consumer. It's going to be good for the company. And then we have to rewrite the contracts and meet any specific requirements. This is just the way business ought to be done. So I think what this is going to do is eliminate those guys who want to skirt the law, come back and say, hey, this is what you should have done. But the guys who are complying or trying to comply, it's not going to be an issue. Thank you.
Thank you, sir. I can't see. Is there any other member of the public or anyone else present that wishes to address the board on this matter? Okay.
I believe that concludes the comment period of this rulemaking hearing. Now, if we want to go back real quick, if the board wants to make a motion to add the red line copy of the renewal and certification and license as Exhibit 1 to the record, and then also, I believe you can do it in one motion, add the notice of rulemaking hearing as Exhibit 2 to the record.
And the first part of this amendment, it would show the motion that was passed to make whatever correction in the language that was accidentally deleted out of the red line copy.
That'll be, I mean, these are just the documents that we used in this meeting, but it's on the record that the board went back and corrected that.
I just want to make sure when we
Right.
say red line copy, it encompasses the motion that we cleared that up with. So one motion for Exhibit 1 and Exhibit 2, correct?
Right, yes.
Okay.
We'll make a motion to accept the red line copy of the rulemaking hearing and the rulemaking hearing as presented, Exhibits 1 and 2.
Okay. We have a motion by Ms. Jones to accept the red line copy as Exhibit 1 and the entire notice of rulemaking hearing as Exhibit 2. Do we have a second?
Second.
Okay, we have a motion and a second on this. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Okay, at this time, I'm going to continue with the economic impact statement and statement regarding projected financial impact on local governments for these proposed rules before the board votes to adopt the rules. And I have included the considerations for the economic impact statement as well as the impact on local governments in the handout that I gave you. And I went ahead and took the liberty to prepare recommendations. The board is certainly free to make their own if they wish on the record, or make any amendments to mine that I've proposed there. And the board will need to adopt responses to each consideration by motion. So if we just want to start there on the economic impact statement document. And this is done pursuant to the Regulatory Flexibility Act, which is TCA 45401 et sec. As part of the rulemaking process, each agency must prepare an economic impact statement as an addendum to each rule that is deemed to affect small businesses, which shall be published in the Tennessee Administrative Register, filed with the Secretary of State's office, and made available to all interested parties, including the Secretary of State, Attorney General, and Reporter, and the House and Senate Government Operations Committees. And this requirement is found at TCA 45403. And the statement shall include the following, and it starts at number 1. Board wants to look over those and make motions on numbers 1 through 6 there. I can read them if you'd like into the record. So number 1, the type or types of small business and identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. And as the model response there, I put, these rules are not expected to have a measurable impact on the cost to small businesses.
Vote on, do a motion and vote on this one and then move to the next. Okay. Do we have a motion to accept or reject number 1 on our economic impact statement?
At this point, we don't have anything, we're not requiring anything to be printed or reprinted. We changed.
I believe we took that out by motion earlier when we decided to delete that section regarding printing the board's phone number and contact information.
I'll make a motion to accept this rule.
Second.
Okay, we have a
Or is-
motion by Ms. Jones and a second by Mr. Cockcroft to accept number 1 on our economic impact statement. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Number 2,
2, the projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. Model answer, there are no projected reporting, record keeping, or other administrative costs required for these proposed rules.
motion to accept or reject this response to number 2.
I would make a motion that we accept the response that there are no projected reporting, record keeping, or other administrative costs required for the proposed rules.
I'll second.
Okay, we have a motion by Mr. Cockcroft, a second by Ms. Jones to accept number 2's answer as presented. All in favor, voice by saying aye.
Aye.
All opposed? Move to number 3.
Statement of the probable effect on impacted small businesses and consumers. Model answer, there is no expected adverse impact on small businesses as a result of these proposed rules. The proposed rules are expected to assist with the protection of the welfare and safety of the citizens of the state of Tennessee by seeking to further clarify provisions in the law regarding issues such as code of conduct of licensees and door-to-door solicitation, and the reporting requirements regarding status changes and arrests of licensees.
Do we want to be so specific to put door-to-door, or can we change that to where it includes all solicitations? Because, you know, we discussed
yeah, you
telephone
could say-
solicitations.
You could say just, such as code of conduct of licensees, in solicitation. So just take out the door-to-door.
I think if we encompass all of it.
Make a motion we accept with the amendment of removing door-to-door.
Second.
Okay, we have a motion and a second to amend the response to number 3 on the economic impact statement. All in favor, voice by saying aye.
Aye.
Now do we have a motion to accept it with it being amended?
I accept it as amended. Motion.
Okay.
Second.
Okay, we have a motion and a second now to accept number 3 in its amended form. All in favor, voice by saying aye.
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 All opposed, the motion passes.
Number 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small business. Model answer, there are no less burdensome, less intrusive, or less costly alternative methods known which will achieve the purpose and objective of these proposed rules.
I make a motion to accept number 4.
Second.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to accept number 4 as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 5, a comparison of the proposed rule with any federal or state counterparts. Model answer, there are no known federal or state counterparts to these rules.
Make a motion, we accept number 5.
Okay, we have a motion by Ms. Jones. Do we have a second?
And we do know that, I guess, that there aren't federal or state, I mean, that would relate to the whole.
Sorry, I didn't.
There aren't any other, I guess that, I know there aren't any other state statutes that as far as regarding alarms, but as far as any of the contracting requirements or any of the other stuff, there's not anything. There are federal counterparts as far as and maybe it's not a counterpart, maybe as far as the 3-day right of rescission on contracts and that sort of thing.
Yeah, I mean, I think that's just under general contract law, but I'm not sure, I mean, after the discussion earlier, but I mean, I'm not sure that the board isn't seeking to,
Change any of
interfere
those.
with contracting, I mean.
Okay. I would make a motion to accept 5 as presented.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to accept number 5 as presented. I thought Karen had already made the motion.
You'd already made a motion.
First and then.
And then I
second.
started asking questions. Sorry. Well, then I'll second her motion. I apologize.
So the way I read it is correct. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries.
Sorry.
It's okay.
6, analysis of the effect of possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. Model answer, any possible exemption of small businesses from these rules would result in less protection for the citizens of the state of Tennessee.
I make a motion to accept 6 as presented.
A second.
Okay, we have the motion by Mr. Cockcroft and a second by Ms. Jones to accept number 6 as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Also pursuant to TCA 45228, a simple declarative statement must be adopted regarding whether the rules may have a projected financial impact on local governments. The model answer I've given is these rules are not reasonably viewed as having a projected financial impact on local governments.
I make,
What is that? That one doesn't have a number. That's,
no, we just,
That's just the final matter. That's just the simple declarative statement.
Need a motion, correct?
Yes.
make a motion to accept Josh's explanation.
second.
Okay, we have a motion and a second. Motion by Ms. Jones and a second by Mr. Cockcroft to accept the declarative statement as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Finally, now the board will address by motion whether it wishes to adopt the proposed rules, and it will be voted upon by a roll call vote.
Ms. Jones? In favor?
I gotta have a motion.
Okay, have a motion first.
Okay, we need a motion to accept these rules as presented by Mr. Kilgore today in their entirety and with the corrections made. And then a second, and then we'll do the roll call oral vote, correct? Okay.
Second. Or did you make the motion?
I voiced
I'll
it.
make the motion that we accept the rulemaking hearing as Josh just proposed it.
I think you, at this point, yes.
I'm not going to vote on it in its
Okay.
entirety. I'm sorry, but I
Due
don't.
to that, am I allowed under Robert's rules to second this? Yeah, I can vote. Okay, I'll second Ms. Jones's motion. All in favor, voice by saying aye. Aye. All opposed?
Roll call.
Oh, that's right, we gotta do the roll call, I'm sorry.
Karen Jones,
So moved.
Vivian Hickson,
Yes.
Scott Cockcroft.
No.
Motion carried, Madam Chair.
And I believe that concludes the rulemaking hearing, and thank you all.
Thank you. Thank you, sir.
Howard, he's my CCTV teacher. If the accounting industry.